Tax protesters in the United States advance a number of constitutional arguments asserting that the imposition, assessment, and collection of the federal income tax violates the United States Constitution. These kinds of arguments, though related to, are distinguished from statutory and administrative arguments, which presuppose the constitutionality of the income tax, as well as from general conspiracy arguments, which are based upon the proposition that the three branches of the federal government are involved together in a deliberate, ongoing campaign of deception for the purpose of defrauding individuals or entities of their wealth or profits. Although constitutional challenges to U.S. tax laws are frequently directed towards the validity and effect of the 16th Amendment, assertions that the income tax violates various other provisions of the Constitution have been made as well. First Amendment. Some protesters argue that imposition of income taxes violates the First Amendment freedom of speech because it requires the subject of the tax to write information on a tax return. This argument can be rejected as specious because what the First Amendment protects is the right to communicate, and does not in any manner provide any right not to say anything. Violates freedom of religion if the subject of the tax claims some religious objection to the payment of taxes, particularly if the subject styles himself or herself as a reverend, minister, or other religious office holder. While the Internal Revenue Code makes an exemption for churches and other religious institutions, it makes only special tax codes and deductions, not exceptions, for religious professionals. The United States Supreme Court held in 1878 Reynolds v. United States, that a religious belief, however strongly held, does not exempt the believer from adhering to general laws. Fifth Amendment. Self-incrimination. Other protesters argue that the Fifth Amendment right against self-incrimination allows an individual to refuse to file an income tax return calling for information that could lead to a conviction for criminal acts from which the income was derived, or for the crime of not paying the tax itself. In response, the courts generally refer to the case of United States v. Sullivan, where Justice Oliver Wendell Holmes wrote, "If the form of return provided called for answers that the defendant was privileged from making, he could have raised the objection in the return, but could not on that account refuse to make any return at all. It would be an extreme if not an extravagant application of the Fifth Amendment to say that it authorized a man to refuse to state the amount of his income because it had been made in crime. But if the defendant desired to test that or any other point, he should have tested it in the return so that it could be passed upon. He could not draw a conjurer's circle around the whole matter by his own declaration that to write any word upon the government blank would bring him into danger of the law. In short, a person could refuse to answer a question if that particular answer could incriminate them, e.g., a professional killer could decline to answer the question of what his or her occupation was. All that is necessary to ask is, could the answer to the question, alone, provide a link in the chain necessary to provide evidence to a crime? Saying your occupation is assassin or professional killer could, and therefore the Fifth Amendment could be invoked as to that question. Saying you made $635,000 last year does not provide evidence of anything criminal, and thus it could not. Takings Clause. Some protesters have argued that the income tax is a prohibited takings under the Fifth Amendment's Takings Clause, and cannot be imposed unless the taxpayer receives just compensation. The United States Supreme Court rejected this argument in Brushaber v. Union Pacific Railroad. The takings argument and variations of this argument have been officially identified as legally frivolous federal tax return positions for purposes of the $5,000 frivolous tax return penalty imposed under Internal Revenue Code Section 6702A. Due Process Clause. Protesters argue that the income tax violates the Fifth Amendment right that no person shall be deprived of life, liberty, or property, without due process of law. However, people can be deprived of life, liberty, or property with due process of law. This is what the courts do. Legal commentator Daniel B. Evans describes, "Every time a court finds a defendant guilty, the court has deprived the defendant of life or liberty, and every time a court rules in favor of a plaintiff or defendant, the court has deprived either the plaintiff or the defendant of some property." So saying that a court has deprived someone of life, liberty, or property is not particularly interesting unless you can explain exactly what the court did, or did not do, that deprived that particular someone of due process. Similarly, the general proposition that every man has the right to his own labor does not necessarily lead to the conclusion that the government cannot tax the common right of labor. If the government could never impose a tax that took away someone's rights to their property, then the government could never tax anyone for anything. So the claim that a tax deprives someone of property or a right is pretty much meaningless. Fifth Amendment due process arguments by tax protesters were rejected by the United States Court of Appeals for the Third Circuit in Conn v. United States, by the United States Court of Appeals for the Fifth Circuit in Anderson v. United States, by the United States Court of Appeals for the Seventh Circuit in Cameron v. Internal Revenue Serv, by the United States Court of Appeals for the Eighth Circuit in Baskin v. United States, by the United States Court of Appeals for the Ninth Circuit in Jolly v. United States, and by the United States Court of Appeals for the Tenth Circuit in Martinez v. Internal Revenue Serv. 13th Amendment. Tax protesters have argued that income taxes impose involuntary servitude in violation of the 13th Amendment. That argument was ruled to be without merit in Porth v. Broderick, United States Collector of Internal Revenue for the State of Kansas. The involuntary servitude argument, and variations of this argument, have been officially identified as legally frivolous federal tax return positions for purposes of the $5,000 frivolous tax return penalty imposed under Internal Revenue Code Section 6702A. 14th Amendment. Some tax protesters argue that all Americans are citizens of individual states as opposed to citizens of the United States, and that the United States therefore has no power to tax citizens or impose other federal laws outside of Washington, D.C. and other federal enclaves. They cite the first sentence of Section 1 of the 14th Amendment, which states, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." Courts have uniformly held that this argument that the 14th Amendment divested state citizens of U.S. citizenship is plainly incorrect. In Cantor v. Wellesley Galleries, Limited, the court explained that while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. See also United States v. Ward Fox v. Commissioner, and United States v. Baker. Another argument raised is that because the federal income tax is progressive, the discriminations and inequalities created by the tax should render the tax unconstitutional under the 14th Amendment, which guarantees equal protection under the law. Such arguments have been ruled without merit under contemporary jurisprudence. Notably, some tax protesters contend that the 14th Amendment itself was never properly ratified, under the theory that the governments of southern states that supported the post-Civil War constitutional amendments were not representative of the people. 16th Amendment. It has been argued that the imposition of the U.S. federal income tax is illegal because the 16th Amendment, which grants Congress the power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration, was not properly ratified, or that the amendment provides no power to tax income from labor. Proper ratification of the 16th Amendment is disputed by tax protesters who argue that the quoted text of the amendment differed from the text proposed by Congress, or that Ohio was not a state during ratification. 16th Amendment ratification arguments have been rejected in every court case where they have been raised and have been identified as legally frivolous. Some protesters have argued that because the 16th Amendment does not contain the words repeal or repealed, the amendment is ineffective to change the law. Others argue that due to language in Stanton v. Baltic Mining Co., the income tax is an unconstitutional direct tax that should be apportioned, divided equally amongst the population of the various states. Several tax protesters assert that the Congress has no constitutional power to tax labor or income from labor, citing a variety of court cases. These arguments include claims that the word income as used in the 16th Amendment cannot be interpreted as applying to wages, that wages are not income because labor is exchanged for them, that taxing wages violates individuals' right to property, and several others. 17th Amendment. An argument raised in the case of Trojimovic v. Commissioner is that the 17th Amendment to the United States Constitution was not properly ratified, and that all laws passed by Congress since the year 1919, which was not the year of ratification, are invalid. The Trojimovic case involved a criminal contempt charge against the taxpayer in connection with a failure to obey a subpoena to produce books and records needed for the trial of the case. The United States Tax Court stated, "The petition in this case, while rambling and lengthy, appears to rely primarily on arguments that neither the Internal Revenue Service nor this court has authority to determine petitioner's tax liability because the 17th Amendment to the Constitution, which changed the method of electing senators to the U.S. Congress, was improperly proposed and/or adopted, and therefore all laws enacted by Congress, and the Senate, subsequent to at least 1919 are invalid." This included the Internal Revenue Code and the legislation which established this court. The court rejected the taxpayer's arguments, and ordered that he be imprisoned for 30 days as punishment for criminal contempt in failing to obey court orders or subpoenas. Titles of Nobility Amendment. Another tax protester argument centers upon the pending and inoperative Titles of Nobility Amendment. Proposed as an amendment to the Constitution by the 11th Congress in 1810, it would, if ratified by the required number of states, strip United States citizenship from any citizen who accepted a title of nobility from a foreign government. The contention here is that this amendment was in fact ratified by the required number of states, in the 1810s, to have become an operative part of the Constitution, and that, because this is so, actions taken by lawyers and judges, who use the title Esquire asserted to be a title of nobility and monarchical are unconstitutional. In fact, the use of Esquire by lawyers and judges is merely an informal custom in the United States, not a title with any legal standing. This contention, rarely raised before courts, was most recently addressed in Campion v. Towns, No. CV 04-1516 PHXROS, *2N.1, D. Arizona 2005, as a defense to a charge of tax evasion. The court replied. Additionally, the court will correct any misunderstanding plaintiff has concerning the text of the 13th Amendment to the United States Constitution. In his complaint, plaintiff includes a certified copy of the 13th Amendment from the Colorado State Archives which was published in 1861. As included in that compilation, the 13th Amendment would strip an individual of United States citizenship if they accept any title of nobility or honor. However, this is not the 13th Amendment. The correct 13th Amendment prohibits slavery. Although some people claim that state publication of the erroneous 13th Amendment makes it valid, Article V of the Constitution does not so provide. Federal government authority. Neither the U.S. Supreme Court nor any other federal court has ruled that an income tax imposed under the Internal Revenue Code of 1986 is unconstitutional. Under the Supreme Court ruling in Cheek v. United States, a defendant in a tax evasion prosecution who has made arguments that the federal income tax laws are unconstitutional may have the arguments turned against him, or her. Such arguments, even if based on honestly held beliefs, may constitute evidence that helps the prosecutor prove willfulness, one of the elements of tax evasion. Sovereign individual and government privilege. Some tax protesters argue that they should be immune from federal income taxation because they are sovereign individuals or natural individuals, or on the ground that they have not requested a privilege or benefit from the government. These kinds of arguments have been ruled without merit. For example, in the case of Laval v. United States, the United States Court of Appeals for the Seventh Circuit stated, plaintiffs argue first that they are exempt from federal taxation because they are natural individuals who have not requested, obtained, or exercised any privilege from an agency of government. This is not a basis for an exemption from federal income tax. All individuals, natural or unnatural, must pay federal income tax on their wages, regardless of whether they received any privileges from the government. Plaintiffs also contend that the Constitution prohibits imposition of a direct tax without apportionment. They are wrong, it does not. U.S. Constant Amend. 16. The Court of Appeals in Lowell affirmed a U.S. District Court order upholding a frivolous return penalty under 26 U.S.C. 6702a. Similarly, in United States v. Sloan, the taxpayer's contention that he is not a citizen of the United States, but rather, that he is a freeborn, natural individual, a citizen of the state of Indiana, and a master not servant of his government was ruled to be not a legal ground for the argument that the taxpayer was not subject to the federal tax laws. The tax evasion conviction was upheld by the United States Court of Appeals for the Seventh Circuit. Similarly, the United States Court of Appeals for the Third Circuit stated, in Powers v. Commissioner, Powers contends that either he is immune from the tax laws, or he is a slave to the federal government. This false choice is a creature of Powers' tax protester ideology, not the laws of this republic. Similarly, in 2008, the United States Court of Appeals for the Tenth Circuit rejected a taxpayer's argument that gains of an individual's labor could be taxed only if the gains were received from a federal venue. In that case, the taxpayer's argument that the IRS had no ability to impose a tax on the taxpayer because he was a citizen of the several states, but not a federal U.S. citizen was ruled to be frivolous. Variations of the argument that an individual is a sovereign have been rejected in tax cases such as United States v. Hart, Risner v. Commissioner, Maxwell v. Snow, Roe v. Internal Revenue Serv, Coben v. Commissioner, and Glavin v. United States. The argument that an individual who received Form W-2 wages or other compensation is not subject to federal income tax because the individual has neither requested, obtained, nor exercised any privilege from an agency of government was ruled frivolous by the United States Court of Appeals for the First Circuit in Sullivan v. United States and again in Kelly v. United States. See also United States v. Burris. Argument that the taxpayer can be subject to an excise tax only if he benefits from a privilege extended by a government agency was rejected. Nichols v. United States, and Olson v. United States. The argument that an individual who received Form W-2 wages is not subject to federal income tax unless the tax is imposed in connection with government-granted privileges was ruled frivolous by the United States Court of Appeals for the Seventh Circuit in Coleman v. Commissioner. The argument that an individual who received Form W-2 wages is not subject to federal income tax unless the taxpayer enjoys a grant of privilege or franchise was ruled frivolous by the United States Court of Appeals for the Eighth Circuit in May v. Commissioner. The argument that an individual who received Form W-2 wages is not subject to federal income tax unless the taxpayer has obtained a privilege from a governmental agency was ruled frivolous by the United States Court of Appeals for the Ninth Circuit in Olson v. United States, and by the United States Court of Appeals for the Tenth Circuit in Prout v. United States. In the case of Steward Machine Company v. Davis, the Supreme Court rejected the argument that the relation of employment is one so essential to the pursuit of happiness that it may not be burdened with a tax, and upheld the validity of the Social Security tax. The court stated, natural rights, so-called, are as much subject to taxation as rights of less importance. An excise is not limited to vocations or activities that may be prohibited altogether. It is not limited to those that are the outcome of a franchise. It extends to vocations or activities pursued as of common right. Regarding the taxability of income in connection with events or activities not involving a government privilege or franchise, the United States Supreme Court stated in United States v. Sullivan that gains from illegal traffic in liquor are subject to the federal income tax. The U.S. Supreme Court ruled in Rutkin v. United States that the receipt of money obtained by extortion is taxable as income to the wrongdoer. The U.S. Supreme Court ruled in James v. United States that the receipt of money obtained through embezzlement is taxable as income to the wrongdoer, even though the wrongdoer is required to return the money to its owner. The argument that a person's income is not taxed when the person rejects or renounces United States citizenship because the person claims to be a citizen exclusively of a state, and variations of this argument, have been officially identified as legally frivolous federal tax return positions for purposes of the $5,000 frivolous tax return penalty imposed under Internal Revenue Code Section 6702a. Federal Zone. Some tax protesters argue that under Article I, Section 8, Clause 17 of the Constitution, federal income taxes can be imposed only inside so-called federal zones, areas such as the District of Columbia, military bases, or other places over which Congress has direct authority. This argument is based in part on the U.S. Supreme Court decision in the case of United States v. Bevins. In Bevins, the parties argued over whether a federal court in Massachusetts had jurisdiction over the case of a U.S. Marine charged with a murder that occurred on a ship in Boston Harbor. No issues regarding federal income taxation or the Internal Revenue Code were presented to or decided by the court in the Bevins case. The Internal Revenue Code and the Internal Revenue Service did not yet exist in 1818, when the Bevins murder case was decided. The Clause 17 argument was specifically rejected in the case of United States v. Soto. Defendants argue that Clause 17 limits the legislative power of Congress such that the only geographical areas over which Congress may legislate, or may exercise its power of taxation, are those areas described in Clause 17. This position is contrary to both the natural reading of the Constitution and the case law. Clause 17 limits not the power of Congress, but the power of the states. Keyword exclusive was employed to eliminate any possibility that the legislative power of Congress over the district was to be concurrent with that of the ceding states. Similarly, it is clear that the power of the Congress to collect taxes, created by Article I, Section 8, Clause 1 of the Constitution, is an independent power which is not limited by the other specific powers enumerated in Section 8. United States v. Butler, 297 U.S. 1, 65-66, 56 SCT 312, 319, 1936. It is thus readily apparent that Congress's power to tax extends beyond the exclusive legislative districts contemplated by Clause 17. Defendants' motion to dismiss based on Clause 17 is denied. The Clause 17 argument was also unsuccessful in Cieloro v. United States, Internal Revenue Service. Some tax protesters contend that the U.S. Supreme Court decision in Queja v. United States restricts the jurisdiction of the federal government to impose income taxes inside the states, based on the following language from the court's opinion. This statute is one of universal application within the territorial limits of the United States, and is not limited to those portions which are within the exclusive jurisdiction of the national government, such as the District of Columbia. Generally speaking, within any state of this Union the preservation of the peace and the protection of person and property are the functions of the state government, and are no part of the primary duty, at least, of the nation. The laws of Congress in respect to those matters do not extend into the territorial limits of the states, but have force only in the District of Columbia, and other places that are within the exclusive jurisdiction of the national government. Some tax protesters contend that the court's reference to those matters restricted the federal government's jurisdiction over matters of taxation. Queja is not a tax case. The reference to this statute was a reference to a perjury statute. The Queja case involved a perjury conviction where the defendant unsuccessfully argued that the federal court had no jurisdiction over a prosecution for the crime of perjury committed in a proceeding in a land office at Kingfisher, Oklahoma regarding ownership of real estate. The reference in Queja to the laws of Congress in respect to those matters was a reference to the matters of preservation of the peace and the protection of person and property. The court in Queja rejected the argument that the federal courts had no jurisdiction to hear a case under the perjury statute, and the defendant's conviction was affirmed. No issues involving the power to impose and enforce federal taxes in the 50 states were presented to or decided by the court in Queja. The courts have uniformly rejected the federal zone argument that congressional authority to impose an income tax is limited to the District of Columbia, forts, magazines, arsenals, or dockyards, etc. See, for example, United States v. Mont, Nelson v. Commissioner, Abbs v. Imhoff. Definition of income. Stratton's Independence, Limited v. Halbert. Some tax protesters have cited the U.S. Supreme Court case of Stratton's Independence, Limited v. Halbert for the argument that an income tax on an individual's income is unconstitutional. This was an argument raised unsuccessfully by John B. Hill, Jr., in Hill v. United States, and without success by John B. Cameron, Jr., in Cameron v. Internal Revenue Serv. In Stratton, a mining corporation argued that the 1909 Corporation Tax Act did not apply to that corporation. The U.S. Supreme Court ruled that the 1909 Corporation Tax Act did apply to mining corporations, and that the proceeds of ores mined by the corporation from its own premises were income within the meaning of the 1909 Tax Act. The court also ruled that the corporation was not entitled to deduct the value of such ore in place and before it is mined as depreciation within the meaning of the 1909 Act. The Stratton case involved income taxation of a corporation, not of individuals. The court in the Stratton case did not rule any corporate or individual income tax as unconstitutional. Doyle v. Mitchell Brothers Co. Some tax protesters have cited Doyle v. Mitchell Brothers Co. for the proposition that income of individuals cannot be taxed. This was the argument raised unsuccessfully by Joseph T. Tornacchio in the case of Tornacchio v. United States and by Joram Pearl in Pearl v. United States, also unsuccessfully. The following language is sometimes cited by protesters. Yet it is plain, we think, that by the true intent and meaning of the Act the entire proceeds of a mere conversion of capital assets were not to be treated as income. Whatever difficulty there may be about a precise and scientific definition of income, it imports, as used here, something entirely distinct from principal or capital either as a subject of taxation or as a measure of the tax, conveying rather the idea of gain or increase arising from corporate activities. The above verbiage is immediately followed in the text of the case by this sentence. As was said in Stratton's Independence v. Haubert, 231 U.S. 399, 415, 34 S. Sup. Ct. 136, income may be defined as the gain derived from capital, from labor, or from both combined. In Doyle, the taxpayer was a corporation engaged in the manufacture of lumber. In 1903, the taxpayer purchased certain timberland at a cost of about $20 per acre, $49/ha. As of December 31, 1908, the value of the land had increased to about $40 per acre, $99/ha. The Corporation Excise Tax Act of 1909 was enacted on August 5, 1909, and was effective retroactively to January 1, 1909. For the years 1909 through 1912, the taxpayer filed tax returns under the 1909 Act, showing gross receipts from the sale of manufactured lumber and, in arriving at the amount of net income subject to tax under the 1909 Act, deducted an amount based on the $40 per acre value, rather than the actual cost of about $20 per acre. The Commissioner of Internal Revenue argued that the taxpayer should be able to deduct only an amount based on the taxpayer's historical cost basis of $20, rather than the $40 fair market value at the time the 1909 Act became effective. Essentially, if the taxpayer were allowed to use the $40 per acre value as its basis rather than the actual $20 historical cost basis, a portion of the taxpayer's gain, the increase in value from 1903 to December 31, 1908, would go untaxed. The U.S. Supreme Court ruled that under the 1909 Act, which had become effective January 1, 1909, the taxpayer should be taxed only on the increase in value after 1908. Increases in value prior to the effective date of the statute were not to be taxed under the terms of that statute. Thus, the taxpayer was entitled to deduct, from its gross receipts from the sale of finished lumber, a basis amount computed with reference to the $40 per acre value as of December 31, 1908. Doyle is a case involving statutory, not constitutional, interpretation. In this case, the court was interpreting the 1909 statute. Although some tax protesters cite this case for an argument about the constitutional definition of income as excluding income of individuals, no issues involving the constitutional definition of income, or of income under any other tax statutes, were presented to or decided by the court. The case is also notable for the fact that it involved a retroactively imposed tax. The taxpayer did not argue and the court did not rule that as a general proposition taxes could not be imposed retroactively. Indeed, the tax in this case was imposed retroactively. The statute was enacted in August 1909 but was made effective retroactively to January 1, 1909. Corporate profits. One argument repeatedly made by tax protesters is that the income of individuals is not taxable because income should mean only corporate profits or corporate gain. This is the Merchants' Loan argument, named after the case of Merchants' Loan and Trust Company, as trustee of the estate of Arthur Ryerson, deceased, plaintiff in error v. Julius F. Smietanka, formerly United States Collector of Internal Revenue for the 1st District of the State of Illinois. The argument is essentially that income for federal income tax purposes means only the income of a corporation, not the income of a non-corporate taxpayer, because the United States Supreme Court in that case, in discussing the meaning of income, mentioned a statute enacted in 1909 that taxed the income of corporations. The court in Merchants' Loan was specifically interpreting a 1916 statute imposing income taxes on individuals and estates, among other kinds of entities, and not the 1909 corporate tax statute. The taxpayer in Merchants' Loan was not a corporation but was the estate of Arthur Ryerson, deceased. The court was not presented with, and did not decide, any issue involving the taxability of corporate profits or corporate gains or any other kind of income except the gain on the sale of the stock by the estate of Arthur Ryerson, deceased. The terms corporate profit and corporate gain are not found in the text of the court's decision in Merchants' Loan. In Merchants' Loan, the Supreme Court ruled that under the 16th Amendment to the United States Constitution and the 1916 tons.
Please subscribe and thanks for watching.